Hi everyone, this is Rajesh Kumar. Today we are going to see a synopsis of an excellent book. The topic is about adverse possession. Disclaimer: the video content is mainly for educational purpose only, and you can read the whole paragraph. First, starting with the introduction. Adverse possession allows a person who occupies and possesses someone else's land without the permission to eventually become the legal owner of the land. This is very special case. The concept is indeed unique aspects of the English law, and obviously it has raised some interesting debates and controversies. The law of adverse possession is based on the principle that the land should not remain in a state of a legal limbo. That's the only intention. If the owner neglects it or fails to assert their rights over the prolonged period, obviously the prolonged period differs from state to state, legislation to legislations, that we can see in the upcoming slides. It provides a mechanism for resolving the disputes and giving a recognition to practical reality of land occupation. If someone wants to acquire a land through adverse possession, he has to meet some conditions. These conditions typically include number one, actual possession. Second one is open and notorious possession. Third one is hostile possession. Fourth one is continuous possession. Let's see first what is actual possession. The trespasser must physically occupy the land. Okay, he has to be there and treat it as their own. They must demonstrate that they have the exclusive control over the property, excluding the true owner and other third parties. That's the main thing. Okay, he has to excluding the true owner and the other third parties. That's the main thing. And another important point is they have to treat it as their own. Okay. The second one is open and notorious possession. The possession must be visible and obvious to anyone who has a reasonable opportunity to observe it. It should not be concealed or very in a manner of secrets. Okay, it should be open and notorious. A third point is the hostile possession. The possession must be without the owner's permission or the right. He should not allow the person to go and stay. It should not be like the possession should not be with the owner's permission or the right. However, this does not necessarily imply ill intent. So at the same point, it should not be ill intent also. It can simply mean that the occupier is asserting their own rights over the land. The fourth and last point is the continuous possession. The trespasser must occupy the land continuously for a specific period, which is typically a number of years. Example, 10 years, 12 years. The period, as I mentioned, have already mentioned, the period may vary depending on the jurisdictions. Okay, if all the four conditions are met, like actual possession, open and notorious possession, hostile possession, and continuous possession, if all these conditions are met, the trespasser may apply to the court to register themselves as the legal owner of the land. The court will consider various factors such as length, how long he was staying, and what is the nature of the possession, the owner knowledge of the occupation, and any action taken by the owner to assert their rights. In order to assert the rights, there should be some action by the squatters. And they will also check the owner's knowledge of this occupation. It is important to note that adverse possession laws differs across jurisdictions, and the specific requirements and procedures may vary. Additionally, the adverse possession is subject to certain exceptions and limitations, okay, such as the land owned by the government or the registered land with the registered owner. So they will see is subject to there are certain exceptions and limitations, like Land owned by government or registered land with a registered owner. The rationale behind the adverse possession is to strike a balance between the interest of the trespasser and the property owner. That's the main thing. It should be a balanced one. It should be like between the interest of the trespasser as well as the property owner. It recognized that long-term occupation, the use of the land, can create stability and certainty. Why they kept 10 years, 12 years? Because the long-term occupation will create a stability and certainty. And moreover, it discourage the dormant or absentee landowners from neglecting their property rights. That's an important point. So, however, adverse possession remains a controversial aspect of the law as it can have a significant implications for the property owners. The critics argues that it allows trespassers to exploit the legal system and unjust deprive lawful owners of the property. They are always the critics. They argue that the trespassers they are exploiting the legal systems and they are not honest like this. The proponents, on the other hand, contend the adverse possession. They are promoting the efficient land use and prevent the land from lying idle. If your intention of the government is to protect the property from being lying as an idle, there are so many ways to do it. Why can't you do that? That's what the proponent's argument is. So the overall, the law of adverse possession reflects the complex and evolving nature of the property rights, and it serves as a unique feature of the English law. Further, there is no legal distinction between the adverse possessors and squatters, unless we reserve the former term, the adverse possessor, only for those peoples who have actually acquired or intending to acquire the title from the paper owner as opposed to mere transient trespassers. Similarly, the squatters and squatting are often used in derogative sense, conjure up an image that it's not a true reflection of the usual people who succeeded in the claim of adverse possession. You can consider the very famous case, the successful claimant in Pye versus Graham case. Further to that, a squatting in a residential building were made a criminal offense with effect from 1st of September 2012 under the section 144 of LASPO Act 2012, Legal Aid, Sentencing and Punishment of Offenders Act 2012. So from 1st of September 2012 onwards, they have considering the squatting in a residential building as a criminal offense. There is also an older offense under Section 7 of Criminal Act 1977 for a trespasser to fail to leave the residential premises when requested by the displaced residential occupier or an individual who is protected intending occupier. Suppose if he gone out and he is requesting you to leave, and if you are still staying there, then it is considered as an offense under the Section 7 of Criminal Act 1977, which is again refurbished through the LASPO Act 2012 under the Section 144. The Land Registry, LandNet, publication number 32, October 12, contains a helpful summary of the impact of the criminal offences, and some of the text is used in this chapter, and we are going to see in details in the upcoming slides. Given that in English law, no person may own the land itself and only an estate in it. You all know that nobody can own a land under the English law. It's only an estate in it. It is in theory perfectly possible for someone other than the paper or real owner to gain a better title without any formal transfer of ownership. So without the transfer of ownership, own the paper or own the paper to get a better title of it. A person title to land, including the paper's owner, is a matter of theory, only as a good as the absence of the person with a better title. Further, the title is thus relative. So either it is relatively better or relatively worse than that of the another person. However, as we shall see, the explanation of adverse possession is nowadays becoming out of date. Although it remains the case under the LRA 2002 that a person is still registered with an estate, not with the land itself. It's clearly says that the registration as a proprietor under the 2002 Act is much more robust, a guarantee of ownership than anything that has gone before. There is still room for alteration of the register, and the adverse possession of the register title is not impossible. But registration of the person as proprietor under LRA 2002 is the closest thing in over 900 years to absolute ownership of the land. So, this has led to the radical overhaul of the law of the adverse possession as it applies to the registered land, and this must be remembered in ensuing the discussions. Similarly, the introduction of the general criminal offense in relating to the squatting in a residential building, it is creating a huge impact on the squatters. The ability to claim the title as it may result in fewer quarters possessing the land for the requisite period of time. So the LRE 2002 Act, after it is being introduced, the numbers might have gone down because it is considered as a criminal offense, especially for the residential buildings. In the Hounslow versus Mincheton case in 1997, land is a finite and a scarce resource, and the principles of adverse possession can help to ensure its full economic and or socialistic utilization. So, in this case, in which the adverse possessor he brought a neglected land back into the use. That's a very special thing about the Hounslow case of 1997. Finally, the public perception is completely different. We should not ignore that. That is, the squatters are to be equated with the land thieves, getting something for nothing. Even if this is a false comparison, but it has proved influentially politically and helped the persuade the parliament to introduce the general criminal offense of squatting in a residential building, as we have discussed just now. So the public perceptions has created or it forced, it's persuaded the parliament to introduce this criminal offense under the new act. The limitation of action is a feature of all legal systems, where, based on the common law or civil law, the impact in relation to the land varies considerably between different jurisdictions. If it is a common law, it's a different scenario, civil law, it's a different scenario. So, on the whole, this reassessment of the role of the adverse possession has proved persuasive, at least in the respect of the land of registered title. The registered title has comprises over 85% of all the titles. Now you can see the new scheme of LRA 2002 has been in force for nearly 15 years, and successful new claims to adverse possession of the registered land has slowed to a thin trickle. That is, the claim in which the adverse possessor had not completed 12 years adverse possession of the registered title prior to the 13th October 2003, a date of entry into force of the LRA 2. This is clearly highlighted in Baxter versus Mannion case. The rule common to both the registered and unregistered land are the substantive principle developed through the case laws over the many decades and now largely settled by the House of Lords under the same popular case JFI Limited versus Graham in 2002. So these rules establish when a claim of adverse possession might succeed factually and apply equally to the registered and unregistered title. Let's move on to how this adverse possession established and how the rules common to unregistered and registered land. Between LRA 1925 and LRA 2002, the crucial question still remains: when will a trespasser be able to establish the adverse possession such that he might be able to stake a claim to the land, or put it in another way, how is the adverse possession established factually? The rules about these are the same, irrespective of whether the land is of unregistered or registered title. In the exam, you can find in the problematic under the problematic question there will be three or four sub top questions. In that, one of the questions will be in the same scenario how it will be treated when it is a registered title, how it will be, how you will handle it, how your advice will change when it is unregistered title. Like that, there will be a question on that. So these slides will help you to answer in a very better way. So, pertaining to the when the adverse possession is being established and whether the land is registered or unregistered title, how it differs. If you see, the relevant principles are not found in any statute, not even in the Limitation Acts 1980 itself, but it has been developed through a lot of case laws over the generations. Let's watch very carefully. We are going to discuss almost like four case laws now. First, Port of London Authority versus Ashmore in 2009. The adverse possession of the river bed by a floating moored vessel. Here, this is settled prior to an appeal when the claimant accepts a license for life. There is no doubt, for example, that some modern decisions have been adverse possessor friendly in the sense that a court no longer manifests an inbuilt hostility to the adverse possessor. Please go through the case of the Chambers versus Havering LBC in 2011. But the picture is not uniform, and sometimes the paper owner is vindicated even though the adverse possessor appear to have a strong claim. For a case such as Smith versus Molinax and 2016. Similarly, although a decision of the Privacy Council in respect of the claim in British Virginia Islands, the substantive law of the adverse possession is identical to that in England and Wales. So, in this case, the England and Wales and the substantive law with respect to the adverse possession are treated identical. Although a decision of the Privacy Council has given a same judgment as in England and Wales, as a matter of law, adverse possession cannot operate in respect to the land over which a public right of way exists. For example, the public right of way is very important point. It contributed a lot in three cases: Broomley LBC versus Morit in 2000, and R versus a land registry case in 2009, or on the application of the Smith versus the land registry's Peterborough office, the 2009 case. These two cases has contributed much to the public right of way exist. Similarly, it is also clear that the acquisition of the title by adverse possession, it does not violate the human rights of the paper owner. Just go through the Oflu versus Bossart, the case in 2008, which accepts the authority of the ECHR decision in Pi versus UK 2008 on this point. In the case of Pi versus UK 2008, it's a ECHR decision in which the Grand Chamber of the European Court of Human Rights decided that the law of adverse possession under the LRA 1925 was compatible with the ECHR. So it's a very remarkable thing. It's both are in line. LRA 1925 related to the adverse possession, the human rights, the European Court of Human Rights has decided that is compatible with the ECHR. Therefore, so must be the law under the LRA 2002, given that it is less generous to the adverse possessors. In contrast, this with the earlier High Court decision, this Bowling Properties versus Palmer in 2005, which is no longer been used or been referred, which attack the essence of the law of adverse possession on human rights grounds. Bowling must now be regarded as unreliable, especially in the light of the decision in Oflu case. This is totally unreliable now. The HM land registry no longer relies on the Bowling case. Yeah, the claim of adverse possession raises both questions of law and fact, and therefore the circumstances which may trigger a claim are virtually unlimited. However, in JP Limited versus Graham case, 2002 case, the House of Lords sought to bring stability to the law by providing a framework within which the cases could be considered. So, together with the earliest decisions of the Court of Appeal in Buckinghamshire CC versus Moron case in 1990, the judgment in Pi provides a definitive statement of fundamental of the modern law without inhibiting its application to unique circumstances. What's the reason? The reasoning of House in Pi forms the basis of the following discussions. In simple terms, adverse possession may be established by demonstrating the required degree of exclusive physical possession of the land, coupled with the intention to possess the land to the exclusion of all others, including the paper owner. This is what we have seen in the introduction slide. So it is therefore the conjunction of acts of possession with an animus possidendi. You will find this term. It's nothing but intention to possess that establish the adverse possession. So in this case, in simple terms, adverse possession means how it can be established by demonstrating. First one is the record degree of exclusive physical possession of the land, coupled with the intention to possess the land, and to the exclusion of all others, including the paper owner. The, these are the points which will establish the adverse possession. In turn, the decision in the Court of Appeal in Buckinghamshire CC versus Moran in 1990, the decision owed much to the early remarkable judgment by Slade J. in Powell versus McFarlane in 1977, which was explicitly approved in Moran case and in Graham case. This is a very important case. Powell versus McFarlane case, whatever the judgment was being given, it is explicitly approved in Moran case and in Graham. According to the Lord Brown in Wilkinson in Graham, the principle set out by Slide as subsequently approved by the Court of Appeal in Buckinghamshire County Council versus Moran case 1990. In Mitchell versus Watkinson case in 2013, for example, of how a possessor may believe that they have the right to land for many reasons, but still succeed through the adverse possession. A point made again in Chamber versus Havering LBC in 2011, where the Court of Appeal sent the case back for retrial because, among other things, the trial judge appears to have used the implied license theory to defeat the claim of the possessor. It's a very important case. Most importantly, as Pi make clear, Pi case make it clear that this means that necessary intent is an intent to possess, not to own, and an intention to exclude the paper owner only so far as is reasonably possible. So the Lord Brown Wilkinson states that, or in the words of Slade's Jane Powell, an intention in one's own name and on one's own behalf to exclude the world at large, including the paper owner, with the paper title, if he be not himself the possessor so far is reasonably practicable and so far as the process of the law will allow. So I will repeat the term in the Pi case where the Lord Brown Wilkinson, or in the words of Slade J. in Powell, states that an intention in one's own name and on one's own behalf to exclude the world at large, including the owner, with the paper title, if he be not himself the possessor, so far is reasonably practicable, and so far as the processes of the law will allow. Hence, as recognized by Slade J. in Powell versus McFarland in 1979 case, the requirement that the adverse possessor must intend to possess the land to the exclusion of all others to some extent is artificial. For example, some adverse possessors may appreciate entirely that the land is not theirs and act deliberately to exclude the world. In other case, may believe honestly that the land is theirs already. So do not for one moment think they are excluding the true owner. So others still may have formulated no intention at all, but simply treat the land as their own because it is theirs. In other words, we are not looking here for intention in traditional legal sense of mens rea, either objectively, subjectively established. No, what is required is evidence that the adverse possessor, for whatever reason, he had an intention to possess the land and put it on his own use. Whether or not, he also knew that some other person had a claim or right to the land. That's it. In other words, the claimant is not required to prove that he believed that the land was his or wanted to acquire it, but more simply that he meant to exclude all others if he could. This is mentioned in William S. Jones case 2003. This is crucial because the claimant is not required to prove that he believed that land was his or he don't want to acquire it. But more simply, he mean to exclude all others if he could. That is the Williams versus Jones case. It means the focus is on the intention of the claimant, not the landowner. Consequently, it is immaterial whether the claimant was unaware that the landowner had intention to use the land in the future. That was consistent with the actual present by the claimant. The landowner's state of mind is irrelevant. This make clear if it were needed that implied license theory is invalid and incorrect in law. So, in other words, the claimant is not required to prove that he believed that land was his or wanted to acquire it, but more simply that he meant to exclude all others if he could. This is the Williams versus Jones case in 2003. It is, in the language of the Lord Brown Wilkinson, heretical and wrong. This is he mentioned in the Chambers versus Havering case in 2011. So we all know that as much was settled by Moran, and although there may be occasions for the genuine implication of such licenses, Lord Brown, Wilkinson, Pye also make it clear that this will be an exceptional. As he says, if the claimant is aware of the special purpose, okay, for which the paper owner uses or intend to use the land, the use made by the adverse possessor, it should not conflict with that use. That may provide some support for a finding as a question of fact that the adverse possessor had no intention to possess the land in the ordinary sense, but only an intention to occupy it until needed by the paper owner. So for myself, I think there will be few occasions in which such inference could be properly drawn in cases where the true owner has been physically excluded from the land, but it remains us a possible, if improbable, inference in some cases. This is the statement by Lord Brown Wilkinson in Pye case. With this judgment, a case that comes closer, that is the Stadium Capital versus Sun Marylebone Property Company PLC in 2009, where the adverse question denied. However, there may have been an express license in this case, which is the Stadium Capital versus Sun Marylebone Property Company PLC in 2009 case. So, in the Lambeth LBC versus Blackburn case in 2001, Blackburn was able to demonstrate an intention to possess the land through the clear act of possession. He just occupied by showing he demonstrated the intention to possess the land. Even though he knew that the land was another's and would have accepted a permission if one had been offered a permission in the form of a lease. So, in the Lameth case, the Blackburn was able to demonstrate an intention to possess the land through the clear act of possession, even though he knew that the landowner was another and would have accepted a permission if one has been offered. Similarly, in BRB, Residuary versus Curley in 2000 case, and also the Smart versus Lambeth LBC in 2013, when an occupier failed in his claim because he had, by his contact, accepted a license from the owner. So they failed in the BRB case in 2001 and the Smart versus Lambeth LBC 2013 case, where an occupier failed in his claim because he had, by his conduct, accepted license from the owner. Likewise, the intention to possess can still exist even if the claimant would have been prepared to accept the permission to use the land had it been offered. The same thing, Lambeth LBC versus Blackburn curse, or even if he would have quitted possession if required. Okay, if required, he will just quit. This is the case in J. Alston and Sons Limited versus BOCM Pauls Limited in 2008 case. Such willingness is not inconsistent with the current intention to possess, even if any subsequent actual acceptance of permission would destroy the intention. A later admission of the land owner title by the claimant is not inconsistent with the claimant having an intention to possess in the meantime. Now, I will explain what is the fact in the Pi case, in which in the Pi case, Graham had made it clear that he would have accepted a grazing license from Pi, but as one was not offered, the Graham's current intention to possess the land until a license was offered and accepted was enough to secure the title by adverse possession. So the another important case, Mitchell versus Watkinson 2013 case, where the claimant had no right to the land between 1974 and 1990, but he accepted a license in 1990. So by then, however, they had possessed the land long enough from 1974 to 1990 to gain the title through the adverse possession. Now you understand? In the Mitchell versus Watkinson case in 2013, they just a long time they were occupied and they had won in adverse possession. Conversely, however, although the adverse possessor mere knowledge of another claim to the land is no bar to adverse possession. For example, the contrary view in the Bat versus Adams 2001, it cannot be a good law after Graham. A belief that the land is currently possessed with the permission of the paper, the owner is fatal. This was the case in Klaus Development versus Walter, in which the claimant believes, even if mistaken, that the land has held under a license means that they simply could not have the relevant intention to possess. As we know, the awareness that the land belongs to another cannot prevent the existence of current intention to possess. We have seen in the Blackburn curse, but an acknowledgement that the land belongs to another will do so. This we have seen in BRB versus Scully case. Put simply, you cannot intend to treat the land as within your ultimate control if you believe that you are permitted to be there by the owner. So, in other words, if you are permitted by the owner, you cannot intend to treat the land as within your ultimate control. Got it? I will put Lord Brown Wilkinson in by case, the statement in a very simple term, where a claimant, the paper owner, is aware of a specific purpose for which they use or intend to use the piece of the land. So, in that case, if another person, the adverse possessor, occupies the land in a manner that does not conflict with the claimant's intended use, it may support the argument that the adverse possessor did not have the intention to possess the land in the ordinary sense. Instead, their intention may be seen as an occupying the land temporarily until the claimants need it. However, it is important to note that the passage suggested that this inference would be rare in cases where the true owner has been physically excluded from the land, or in other words, if the claimant has been physically prevented from accessing or using the land. It would be less likely for the court to draw the inference that the adverse possessor intent was only the temporary occupation. Next, we are moving to a very important subtopic within that. If it is like unilateral permissions, there are so many situations been arisen where the unilateral permission being given and uh, in this respect, the unilateral permission given by the paper owner to the adverse possessor can be fatal for the possessor claim, even if the possessor does not acknowledge or accept the permission. Even he doesn't acknowledge or he didn't accept the permission, but it's fatal to the adverse possession. This was the case in BP Properties vs. Buckler in 1987, where the paper owner unilaterally and unexpectedly gave the permission to the possessor shortly before the expiry of the limitation period. It's very clever. There was no evidence that this has been accepted by the adverse possessor, and certainly it never been requested. The point seems to be that the giving of such permission, even if unwanted, can be the evidence that the adverse possessor no longer has the intention to possess. So it stops there. Okay, if the permission is being given, the adverse possession stops there. Even there is no evidence that the permission was accepted. The point seems to be that the giving of such permission, even if unwanted, can be the evidence that the adverse possessor no longer has an intention to possess, even if there is no evidence that the permission was accepted. This was confirmed by the Privy Council in Smith versus Molinax in 2016. But it was made clear that this should not be taken as a re emergence of implied license theory as referred above. So, the adverse possessor should know that such unwanted permission should not be rejected by any means. That's the important thing. The giving the unilateral permission unacknowledged or unaccepted can lead to a genuine factual interference that the adverse possessor no longer had a requisite intention. Presumably, therefore, in order to maintain their adverse possession, the possessor should make it clear that such unwanted permission is rejected. Finally, as also demonstrated by Pai and Mitchell, if the alleged adverse possessor, once he occupied the land with the permission of the paper owner, but he continued in possession, after that, a permission has ended. For example, the lease or license has ended, but still he continued his possession. This can be the sufficient to support a claim of adverse possession if the animus possidendi is shown as arising when the permissive use ends. When the lease or license ends, from that point, animus possidendi starts, or it is treated as ended because of the intervention of the statute, a measure, nothing the effect of the paragraph 5.1 of Schedule 1 of the Limitation Act 1980. It will be appreciated immediately that this intention to possess might be difficult to prove. There are few difficulties if the alleged adverse possessor has acknowledged the true owner's title in some way. For example, in Arcanel versus Lambert LBC in 2000, the alleged adverse possessor had acknowledged the landowner's title in written correspondence. Even the Rahman versus Benfield case in 2006, similar thing has happened. Conversely, if the adverse possessor had placed a sign at the entrance of the land saying "Keep out, private property," most cases are, however, somewhere in between and can be complicated with the paper owner seeks to give a permission despite this being unwanted by the paper owner. How to answer the question whether the claimant has established the adverse possession. So, enclosing the land by the fence may both constitute the act of possession and demonstrate the intention to possess. That is the warrant case. As might changing the logs to a flat in Blackburn curse, it happened. Or the grazing animals within an enclosed field, the pie case. and the burden of proving the intention may be lighter in cases in which the true owner has to acknowledge the adverse possessor, abandon the land. Abandon the land means you will think about Minchinton case. It is clear that unequivocal conduct in relation to the acts of the possession on the land is the best evidence of an intention to possess. Such acts may need to be more overt where the land was once occupied with permission. With permission means mutual case, or where the paper attempts to give permission, but it will be a question of degree in each case. Hence, we are concluding the intention to possess. Now we are moving to the physical possession of the land. Physical possession of the land. As well as demonstrating an intention to the land, the adverse possessor must also demonstrate the physical taking of possession. In Pi, the Lord Brown Wilkinson explained why too much analysis was a bad thing. In his view, much confusion and complications would be avoided if reference to adverse possession were to be avoided so far as possible. The question is simply whether the defendant squatter has disposed the paper owner by going into honorary possession of the land for the requisite period without the consent of the owner. In simple words, avoiding reference to the adverse possession could potentially reduce confusion and complications within the legal context. It proposes that the key question to be addressed is whether the defendant who is occupying the land without the owner consent has effectively taken possession of the property for a specific period of time. That's it. So, in other words, we should not seek to conceptualize what is adverse and what is not, but ask ourselves the simple ordinary question: is the claimant in possession of the land without the permission of the landowner? That that question will give a clear picture. The test put forward in Powell and adapted in Graham. If you refer to the case, the Dyer versus Terry in 2013, for an example of how fine the line is between the possession and the mere use. In Dyer, the adverse possessors succeeded in respect of some, but not all of the land because their act of possession varied on different parcels of the land. In the Tech Build versus Chamberlain case in 1969, and in Central Midland Estate versus Leicester Dyers in 2003 case, parking of unlimited number of cars on the land was not sufficient as it did not amount to enough control of the land to establish the factual possession. Further, in Red House Farms versus Catchpole in 1977, where the simple act of possession on the marshland, it is accessible only by the boat, were sufficient, and William versus Jones in 2003, where grazing the sheep on the quarry land was sufficient. The taking of possession might reside in series of events or some one-off activities that is maintained thereafter, like in Powell versus McFarland case, or for the paper owner to be inconvenienced by the acts of possession versus it is seen in Troller versus Nut case in 1976. Moreover, whereas the possession will not be presumed lightly from the acts that are equivocal in nature or temporary in purpose, such as growing vegetables or clearing the land to enable one's children to play. This is what happened in Techfield versus Chamberlain case. Even the small act of custody and control might be sufficient if the land has been abandoned, is inaccessible by the paper owner, or is such quality that it does not readily admit of significant possessory acts. That's what we have seen in Red House Farms versus Catchpole case, where only the boat access was sufficient, and Williams versus Jones case, grazing the sheep was sufficient. Thus, in Dyer versus Terry case in 2013, the basic cultivation was enough in respect of the land unusable by anyone else. But mowing the grass and picking up litter in a different large area was not. Okay, got the difference? In Dyer versus Terry in 2013, they were doing the basic cultivation. So that is enough. But mowing the grass or picking up the litter in a different large area was not. Neither does it matter that the act of possession serves a dual purpose, so long as they give a custody and control to the claimant for his own benefit. For example, in mentioned case, the successful adverse possessor had fenced off the part of the claimant's land, apparently to prevent the escape of her dogs, which he exercised on their land. Not surprisingly, the counsel for the paper owner submitted that the enclosure was not designed to exclude the world, but to confine the animals, should not therefore be regarded as a possession. It's a very interesting case. The court, however, took the view that it was the effect of the adverse possession action that was important, not the motive with which they were done. So the council argued that the enclosure is not for excluding the world; it is to confine the animals. But the court, however, they took the view that you should not, you should see only the adverse possessor's action, and you should not see their motive, as we have already discussed. So, if the effect of the fence was to keep the world as well as the keeping dogs, it amounted to physical possession. So this was confirmed in Chambers versus Havering case in 2011, where it was made clear that impact of fencing was very much dependent on the fact of each case. So you should not see the motive, and you should see the action of the adverse possessor. Was the adverse possessor was still required to demonstrate an intention to possess. Although in Britham versus Rose case in 2005, the court notes that the search for the factual portion is more important than the question of whether the adverse possessor intend to exclude the paper owner. So, in answering the question, has the adverse possessor demonstrated a physical portion of the land in the sense of acquiring the custody and control of his own use? It is whole of his activity on the land that is relevant. The individual activities may seem equivocal or trivial, but if you take them together, they paint a picture of a person in control of the land. They will amount to a possession. Assuming that claimant has established both an intention to possess and factual portion of the land under the PI rule, what does it mean? The two governed by LRA 2002, failure to establish the evidential base for adverse possession is fatal. That's the answer. So, by these, we are concluding the physical portion of the land, and we are moving to the impact of human rights on adverse possession. In the Williamson versus the First Country Trust Limited 2003 case, all the relevant event took place before the Human Rights Act 1998 entered into force, and it was accepted that it did not have a retrospective effect. Similarly, the issue turned on adverse possession under the old law of LRA 1925. The judge in Bowlin took the view that the new mechanism of LRA 2002, whereby the registered proprietor he did not automatically lose the title. In fact, he is very likely to retain it. Mean that LRA 2002 was a consistent with the human rights principle that we have already seen. This must be correct by referring to the case Pi versus UK in 2007 case. There are always two parties in this dispute. One is both of them whom may be claiming a violation of their human rights, albeit different rights under the convention. The landowner who may lose their title and the adverse possessor may lose their home. First, in respect of the potential violation of the paper's owner's right, in Bowling Properties versus Palmer case in 2005, the deputy judge had sought to reintroduce a version of heresy rejected by the House of Lords in the Pye case as a mean of dealing with apparent inconsistency between the principle of adverse possession and the human rights guaranteed by the Human Rights Act 1998. It is now clear, following the decision by the Grand Chamber of the European Court of Human Rights in Pi versus UK in 2007, that the law of adverse possession as it applies in favor of the adverse possessor under the LRA 1925 is consistent with human rights law. That's it. In particular, with Article 1 of the Protocol 1 to the Convention. They made it very clear it is LRA 1925 is consistent with the human rights law, and they have referred to the article as well. The Article 1 of the Protocol 1 to the Convention is consistent. In Oflu versus Bossat, 2008 case, The Court of Appeal confirmed that the principle of adverse possessions are as a matter of principle. It's a compliant with the human rights law, and thus a landowner could not seek to challenge a loss of title on the human rights ground because of his own particular circumstances, unless following the Manchester City Council was in Pinnock in 2010 and Hanslow LBC versus Powell case in 2011, the particular circumstances of the paper owner are truly extraordinary. A decision of the Supreme Court in McDonald versus McDonald in 2017 recognized the matter of human rights might be relevant in a dispute between the private landowners. Does not change this outcome because it's having been determined by Pi versus UKs. But the concept and the implementation of the adverse possession is human rights complaint. So there is no basis to challenge the individual application of law unless perhaps the circumstances are truly exceptional as recognized in Pinnock case. What happens when an adverse possessor who has not acquired the title because time has not run in his favor, or perhaps because of the application of LRA 2002, alleges that his human rights are violated and the landowner recover the possession? The argument might be that recovery of possession from an adverse possessor without the title, even in the virtue of the owner's paramount title, contravenes the adverse possessor right to a home under the Article 8 of ECHR. This argument was tested in Malik versus Fazenfeld in 2013, where Sir Alan Watt noted that Article 8 of ECHR could apply where the squatters has trespassed on the private land and established a home there, but that it would be rare for the removal to be disproportional to the contrary to the Article 18. In most of the cases, you can see the granting of possession in favor of the paper owner would be proportionate way of enforcing the owner's property right. Three things are worthy of note. First, it is not controversial, but often a surprise that a person without any rights to the land may nevertheless claim that it is their home, protected by the Article 8. This is long established in the jurisprudence of ECHR and the UK. That is, you please refer to the McCann versus UK case in 2008. The second thing is, Sir Alan Ward accepted that it is possible to enforce the human rights obligations in disputes about the land between private citizens. Okay, so on that basis, the court itself is a public authority, like the Section 3 and Section 6 of the Human Rights Act 1988 make it clear. The recognition of so-called horizontal effect was continuous at the time, albeit that now McDonald case recognized that it is as a possibility, even if a remote one. The previous cases has approached the issue with more hesitation than Sir Alan Ward in Malik case, recognizing the serious impact that widespread reliance on the human rights could have in the property disputes. For example, in the earlier case, the Family Housing Association with Donnellan, it is not cited in the Malik case. The Park J adopted that conventional view that Human Rights Act and the ECHR was not relevant in disputes between the private citizens. In Donald involved an issue under the Article 1, Protocol 1. So was an example of landowners he itself seeking to use the human rights to protect itself against an adverse possession. It's a very different case. As noted, the Supreme Court in McDonald did not see the matter as a choice between so-called horizontal and vertical effect, but rather whether the substantive law effectively balanced the human rights of the party to dispute. This was much more likely in the private party disputes, where the existing statutory and common law framework for the resolution of disputes would normally be taken as an achieved human rights complaints. So consequently, it would be a rare case when an adverse possession dispute would be determined by reliance on the Human Rights Act. The third point is Sir Alan Ward agrees consistently with the Pinnock and MacDonald case that even if the Article 8 were engaged, normally the paper owner would be entitled to possession as this would be a proportionate way of enforcing their own rights. Clearly, there is a possibility that exceptional circumstances might exist which would protect the adverse possessor home against the retaking the possession by the paper owner. But usually, as made it clear in Pinnock, the proprietary claim of the owner will prevail. In Pinnock case, it is made it clear the proprietary claim of the owner will prevail. Thus, as things stands and bearing in mind how swiftly the law of human rights can develop. The normal result in adverse pressure who achieve title is unlikely to be distributed because of violation of human rights of the paper owner, as per the Article 1 of the Protocol 1, rights are not violated. But conversely, an adverse pressure who is evicted before they achieve the title cannot usually complain that this is compromises their human rights to a home under the Article 8 rights. By here, we are finishing the topic, the impact of human rights on adverse possession. Now we are moving to the impact of criminal offenses on claims to adverse possession. Let's start with the impact of criminal offenses on claims to adverse possession. Before entering to this topic, we have to know two definitions: a displaced residential occupier and a protected intending occupier. The first one, a displaced residential occupier is a person who was using the premises as their home immediately before the trespass. And a protected intending occupier is a person who designated by a local authority or the housing association as a person to occupy, or a purchaser who has just bought the premises and then finds them occupied by a trespasser. Now, I think we are clear with the two definitions. It has been noted above that squatting is a residential building was made of criminal offense with effect from 1st September 2012 under Section 144 of Legal Aid, Sentencing and Punishment of Offenders Act 2012. This is not commonly believed the first time that squatting could trigger a criminal offense because under Section 7 of the Criminal Law Act 1977, a trespasser commit an offense if they fail to leave the residential premises when requested by the displaced residential occupier or an individual who is protected intending occupier. We have seen both the definitions already. The land registry, the original view was that if the applicant based his portion on acts which would amount to a criminal offense, then the application for the title by adverse person had to reject outright. However, this was challenged by the claimant to the adverse person whose application has been rejected by the land registry already because he appeared to have been committing this new criminal offense. In the special case, the Best versus Chief Land Register 2015 case, the Court of Appeal, confirming the High Court, held that commission of criminal offence was not itself a bar to achieving the title by adverse possession. So the legislation establishing the offence was silent on the matter. So the reality is that the offence was rushed through Parliament and no one gave any serious thought to the consequences. So that's the truth. And it was well established that not all the unlawful acts concerning the land were fatal to the claim of the land. So, in the another case, the Backwell Management Limited versus Brandwood, the House of Lords had made a distinction between acts that always would be unlawful and acts which were unlawful only because the claimant did not have the right he was now claiming. Consequently, if the criminal offences arises only because the claimant did not have the title to the land, trying to get the title through the established law of adverse possession remained possible. In short, the criminalization of squatting per se does not prevent a squatter who commits the offence from obtaining the title by adverse possession. So, this will be the case where the land is registered or unregistered. Although, because of LRA 2002, the successful claims are much less likely when the title is registered. So, when it is registered, the successful claims are less. By this, we are concluding the subtopic of the impact of criminal offense on claims to adverse possession. Then we are moving to the adverse possession and unregistered. Adverse possession and unregistered land. Conventionally, this is taken to mean that adverse possession does not actually give a title to the adverse possession, but by the virtue of the doctrine of relativity of the title, the person now in actual possession has a best claim to the land and may thereby become the owner of it all intent and purpose. Importantly, the idea of limitations of the action has no application to the land of registered title governed by LRA 2002. That means it does not apply to the registered land where the adverse possession was completed prior to the entry into force by LRA 2002. where it has been replaced by a statutory mechanism that protect protect the registered proprietor in all but a limited number of situations. Let's move on to the limitation period for unregistered. Limitation period for the unregistered land. How long is the limitation period for the unregistered land? For this question, it should come as no surprise to learn that type of limitation period for actions concerning the land depend on the type of the claim and the type of the limitation period and the type of the paper owner. Although there are some general rules, so it depends on the type of the claim and the type of the paper owner. The first rule is in the great majority of cases, the limitation period will be 12 years from the moment of adverse possession of the unregistered title by the adverse possessor. This is the section 15 of the Limitation Act 1980. This is the normal period of limitations for action concerning the land, although now it has no application to the land registered title governed by LRA 2002. Second thing is, where the paper owner of the land is a sole charitable corporation, the period of limitation is 30 years for the moment of adverse possession. The Schedule 1, Paragraph 10 of Limitation Act 1980. So, 12 years for the normal land, for 30 years for the charitable corporations. A third, where the paper owner of the land is a crown, then the period of limitation is 30 years from the moment of adverse possession. The Schedule 1 of Paragraph 11 of Limitation Act 1980. Fourth one is if the land is owned by someone for life with remainders in fee simple to another person. For example, A for life, remainder in fee simple to B. And the limitation period is either adverse possession of 6 years from the date at which the interest is remainder falls into possession, that is the death of the life tenant, if 12 year or more already have been completed against the life tenant, or the adverse portion of the 12 years from the time of the life tenant was disposed. So whichever is longer. This is as per the section 15 of the Limitation Act 1980. I will repeat the fourth case. If the land is owned by someone for the life, with the remainder in fee simple to another person, then the limitation period is either adverse possession of 6 years from the date at which the interest is remained falls into possession, that is, death of the life tenant. Or otherwise, if 12 years or more already have been completed already against the life tenant, or the adverse possession of the 12 years from the time the life tenant was disposed, whichever comes longer, that will be considered. So, assuming the land is held by A for life, remainder to B, the adverse possession of 12 years or more against A will extinguish A's interest, and a further 6 years will be necessary on the death of the A to also to extinguish B's interest. Fifth condition, if the current paper owner is a tenant of the land under a lease, so the period of limitation against the tenant is 12 years. This is as per the Chang Ping Kwan versus Lam Island Development Co. in 1996. The expiry of the period will therefore extinguish the tenant's title in respect of the claim by adverse possessor. Importantly, however, the extinguishment of the tenant's title has no immediate effect on the title of the reversioner, simply because until the end of the lease, the landlord has no right to possess the land at all. That's the yes. Therefore, time does not begin to run against the landlord until the original term of the lease expires. When the original term of the lease expires and assuming 12 years adverse possession against the tenant, so the landlord will have further 12 years to recover the land. This is as per the section 15 of Schedule 1, paragraph 4 of the Limitation Act 1980. Obviously, it is crucial for the application of these rules to know where the lease has ended. This will usually be the expiry of the stated term. Although for an oral periodic tenancy, this is treated as a end of the first period or on the receipt of the last payment of the rent, whichever comes later. That is paragraph 5.1 of Schedule 1 of the Limitation Act 1980. So this was critical in Michel versus Watkinson case where in 2013 for it determined when the period of adverse possession started, hence was complete. That's what the judgment given. So note, however, that although the normal rule is that the landlord right of action against the adverse possession arises when the original term of the lease ends. There is an exception to this. So, if the lease itself gives the tenant an option to renew the lease when it expires, then the adverse possessor who have evicted the tenant also may rely on the right to renew to defeat the landlord's claim to possession. So he first has to renew it, then only he can defeat the landlord's claims to possession. The landlord must, it seems, wait until the period given under the right to renew also has expired. So that is also expired. The rationale is that the landlord could not have evicted the original tenant, so the landlord cannot evict the adverse possession was displaced the tenant. So it works both ways. This is logical, but it does give a light to the idea that the adverse possession title is completely unconnected to that of the paper's owners he disposes. This is a very special case. In Smith versus Laws in 1997, a defendant had been given an occupation license of the disputed land for the life. So her possession was always with the consent of the paper owner. So also this means that the claimant had no right to recover the land during the defendant's life. It also means the defendant had no claim in adverse possession. This is very interesting. If yes, the adverse possessor has adversely possessed A's land for 12 years. He possessed the land, but has left the possession before A commences an action to recover the land. A's title will be bought, and A will be unable to recover the land from whomever now is in the possession. So A's title to the unregistered land has been extinguished. Of course, if S has left the land, there is nobody in the possession, then A may retake the possession, but he has to wait for another 12 years before being confident of defeating a returning yes. However, the issue is complicated if the paper owner applies for first registration of the title after the adverse possession has completed 12 years adverse possession. So, in that case, at first registration of the title, the registered proprietor is bound only by adverse possession of which he has notice or by the rights of an adverse possession as an overriding interest if the adverse possessor is in the actual possession. This is as per the section 11 of LRA 2022. So this means that absent notice and adverse possessor going out of the possession before first registration, even after completing the relevant period of adverse possession against the unregistered title, would have no rights against the first registered proprietor. So although it is arguable that adverse possessor could apply for rectification of the register on the grounds that papers owner's first registration was a mistake. That means it is uncertain whether the adverse possessor who has completed 12-year period prior to the first registration, but whose interest does not override another schedule one, could apply successfully for rectification of the register in order to secure the title for himself. For Section 11 LRA would seem to suggest not, but it is certainly arguable that there has been a mistake which should be rectified. We should not forget, however, the occasions on which the first registered proprietor does not have notice of adverse possession and where the adverse possession is not in actual occupation will be rare indeed. I want to make it simple. If yes is an adverse possessor, has adversely possessed from A's land for 12 years, but he left the property before A take the legal action to recover it. So A title may be considered bought. So this means that A would be unable to recover the land from whoever is currently in possession. So A's title to the unregistered land would be extinguished. However, there is a complication. If the owner A applies for first registration of the title after the adverse possessor S has completed 12 years of adverse possession. So in this case, now he completed the 12 years, now he want to take it over. So at the time of first registration, the registered proprietor would be bound only by adverse possession of which they gave a notice or by the right of adverse possession as an overriding interest. So if the adverse possession is in actual occupation as per the section 11 of LRA 2002. This means that if the adverse possessor S has left the land before the first registration takes place, the registered proprietor A has no notice of adverse possession, then S would have no rights against A. Then S would have no rights against A. So in such a situation, the adverse possessor may argue for rectification of the register on the grounds that paper owner A's first registration was a mistake. Now I think you can understand. Stopping the clock of limitation for unregistered land. A, a successful action for the person or an action seeking a declaration of the title by the paper owner before expiry of the period will necessarily stop the clock. And any claim for the adverse possession will have to begin again. So this is so even if the proceedings are not possession proceedings, provided the court has determined that the paper owner has a title. This is given in the case Higgs versus Leisure Marias Investment Limited 2009. In the respect, a letter sent by the paper owner merely asserting the title is not sufficient to stop the clock. This we have seen in warrant case. Nor in the most cases is a mere issuing of a claim for possession. That is the Markfield Investment Limited versus Evans case. In Section 29 and 30 of the Limitation Act 1980, they provide that adverse possessors cannot succeed if they have acknowledged the paper owner title before the expiry of the limitation period. This we have seen in Collector Borough Council versus Smith in 1992. So we have seen three cases. One is any claim of adverse possession will have to begin again if a successful action for the possession or action seeking declaration of the title by the paper owner before the expiry of the period will necessarily stop the clock. This is we have seen in the case Higgs versus Leshel Marias Investment Limited 2009. Same way, a letter sent by the paper owner merely asserting the title is not sufficient to stop the clock. That is Moran case. Nor in most cases is the mere issuing of the claim of possession. That is Markfield Investment Limited versus Evans case. Section 29 and 30 of the Limitation Act 1980 provides that adverse possessor cannot succeed if they have acknowledged the paper owner's title before the expiry of the limitation period. That is the Collector Borough Council versus Smith case. In Oflu versus Bossart 2009 case, the House of Lords determined that a statement in court pleadings could amount to the acknowledgement of the title of the purpose of the Section 29 of the Limitation Act 1980. But also any written acknowledgement usually operated only at the time it was given, did not amount to a continuing acknowledgement. So if the adverse person continued to assert adverse person after giving a written acknowledgement of the title, the time would begin to run afresh from the date of the acknowledgement. Then the adverse person would occur title if a new period of limitation was completed. So this is the flow itself. Further also made clear in flow if what happens to a written acknowledgement of the title is made in correspondence between the paper owner and the adverse person, that is formally without prejudice, that it does not operate as an acknowledgement in law and may be discounted. So within this, there is a special thing like it may be sufficient for the paper owner to retake the physical portion of the land himself before the expiry of the limitation period. He wants to take over the physically. He want to possess the land. So, however, such self-help is not always successful. We all know that and may attract the attention of the criminal law. So, in the Smith versus Waterman case, 2003, illustrate a claimant adverse possession cannot be interrupted merely by the paper owner going onto the land and doing some symbolic act. Otherwise, mere entry on the land at sometimes by the paper owner would always stop the limitation clock. This is in Saar versus Parry in 2011 case. Although decided under LRA 2002, this case concerned the general principle of adverse possession. Very important case. What it says, as Smith versus Waterman, it's illustrated the claimant's adverse possession cannot be interpreted merely by the paper owner going to the land and doing some symbolic activity. Whereas mere entry on the land at some time by the paper owner would always stop the limitation clock. That is Sar versus Perry in 2011 case. Indeed, as the judge said in Waterman factual position, does not require continuous physical aggression or much depends on the nature of the land itself. So consequently, recovery of possession through self-help by the paper owner in order to stop the clock must also be such as to demonstrate a retaking of custody and the control of land. So, what will happen if the permission is being given by the paper owner, even if it is unwanted or unasked for? So, in some circumstances, it will stop the limitation clock as well. Clearly, if the permission is accepted by the adverse person, this is sufficient. Once he accepted the permission, then by this the adverse person this is sufficient. In BP Properties versus Buckler in 1987 case, where Smith versus Woolnex in 2016 decided an acknowledgement permission given unilaterally by the paper owner may stop the clock if it indicates that adverse person no longer has an intention to possess the land. Clearly, this is an unusual, and the facts must be sufficiently robust to allow the court to interfere that the unacknowledged permission destroys the claim of adverse possession. Let's see what is the effect of a successful claim of adverse possession in the unregistered land. This section deals with the effect of the successful claim of the adverse possession on the land of the registered unregistered title. That is, when the evidential base of adverse possession has been proved and the limitation period has expired. In these cases, the effect of the successful claim of adverse possession vary according to the proprietary interest of the parties involved. In particular, the effect on the tenants has attracted attention in the recent years. Let's see the effect on the paper owner. In the Collection BC versus Smith case in 1992, it introduced an interesting aspect regarding the adverse possession, the effect of the written acknowledgement by the adverse possessor after the limitation period has expired. Here, in this case, the court held that under certain circumstances, such an acknowledgement could prevent the adverse possessor from relying on adverse possession when faced with an action for the possession by the paper owner. This decision appears to be based on the application of the estoppel, where the adverse possession is stopped from denying the paper's owner title due to written acknowledgement freely given. However, the court does not provide a convincing reason for disregarding this limitation of 1980. In this manner, nor does it explain why the paper owner should benefit from the estoppel. So we have to see the Limitation Act 1980 set the time limit within which the legal action must be initiated to recover the portion of the land. So, by allowing a written acknowledgement to override these limits, the court seems to deviate from the statutory framework. Further, the court does not address the precedent set by Nicholson versus England in 1926 case, where an acknowledgement made after the expiration of the limitation period was deemed insufficient to prevent adverse possession. So, this omission raises question about the inconsistency and coherence of legal reasoning in the Smith case. So, considering these factors, it could be argued that the decision in Collector BC versus Smith in 1992 case may be regarded as a per inquirium, indicating that the court overlooked or disregarded the relevant precedents or statutory provisions. However, at present, the cholesterol decisions appears to be the authority for the proposition that a bona fide compromise of a dispute between the two persons. Both of them had a legal advice should be upheld on public policy grounds, even if the limitation period has of 12 years has been run. So this is supported by the another case like trustee in the charity versus Sir John Morden versus Merrick case in 2007, in which the claimant was not permitted to disavow a compromised agreement relationship relating to ownership of the land because he had already entered into an agreement freely and had raised no argument based on the adverse position of the time. So, in other words, a person will be bound by their contract. So, in the context of adverse possession, this seemingly unobjectionable principle does not recognize that there is also a policy consideration recognized and affected by the Act of Parliament, no less to the effect that sleeping on one's rights deprives a person of those rights. So the judgment in the Smith failed to explain why a contract between the parties can override the express provision of the Act of Parliament. Although some commentators accepted that in principle and contracting out of the Limitation Act 1980 should be possible. It is submitted that they should not be permitted save in the most exceptional circumstances. So, in the Maverick case, prior to the compromise agreement, adverse possession had not been an issue between the parties, and one can see why, in those circumstances, the court was prepared to uphold the compromise agreement. By this, we are concluding the effect of the paper owner. We are moving to effect on the adverse possessor of freehold. So, in the case of unregistered land, the adverse possession operates negatively. It prevents the paper owner from suing the adverse possessor and extinguish the paper title, as stated in Section 17 of the Limitation Act 1980. So, there is no formal conveyance of the land from the paper owner to the adverse possessor. So, the adverse possessor does not become the legal owner of the property simply by virtue of adverse possession. Despite this, a successful adverse possession acquires certain rights and abilities regarding the land. So they may go on to the deal with the land as if their own, including selling it, leasing it, leaving it by will, granting easements, performing other actions typically associated with property ownership. So in practice, if you see that although the adverse possession does not have the formal proof of title, they may be able to find a willing purchaser who is willing to accept their claim of established adverse possession. So adverse possession can then convey the land to the purchaser through a deed. So this deed become the first evidence of the adverse possession title and the first evidence of the title of the new purchaser. So let's see how we have already seen about the freeholds. If it is leasehold, how it will differ. In the context of leaseholds and adverse possession, the traditional doctrine states that there is no conveyance of the paper on a unregistered estate to the adverse possessor. So, however, in this doctrine has some unique consequences when applied to leaseholds. When a tenant leasehold estate is successfully adversely possessed 12 years, okay, it will only extinguish the tenant's estate, not the landlord's. The landlord still retain a further period of 12 years after the original lease period to eject the adverse possession and to protect their title. This is because time can only run against a person who has a right to recover the land. And the landlord's right to recover the land arises only when the lease expires. So when the original tenant loses their estate through adverse possession against the adverse possessor, they will remain a tenant via the landlord for the entire duration of the original lease. So during this lease period, the landlord can initiate forfeiture proceedings against the original tenant, such as for the non-payment of rent. If the forfeiture is successful, then they can terminate the lease and accelerate the landlord right to regain the portion of the land. So that's the only way, thereby allowing them to eject the adverse possession earlier than the expiration of the original lease. So forfeiture is the only clause, and the forfeiture will be activated by the non-payment of the rent, majorly by the non-payment of rent. So it is important to know that adverse possessor is not considered the tenant as a, or an assignee of the tenant. As a result, they cannot be held liable for any leasehold covenants except for those that can be enforced as a restrictive covenants under the rules established in the case of Tulk versus Mokshay in 1848. We will see this case in detail in restrictive covenants topic. So before the LRA 2002 made comparison between the registered and unregistered land meaningless. The portion of the registered land under LRA 1925 was different. That is pertaining to the unregistered land. In Central London Commercial Estate Limited versus Kato Kagaku Limited in 1998, the ejected tenant he surrendered its lease to the freeholder. So, and the registered title to the lease was closed. The freeholder sought to evict the adverse possession before the original period of the lease has expired. So, however, the court held that the effect of Section 75 of LRA 1925 was to ensure that tenant original interest was held on the trust for the adverse possessor, and the tenant could not surrender after the period of limitation had done. So, in effect, the court held that tenant's interest in the lease actually did pass to the adverse possessor. So, the adverse possessor could remain on the land for the remainder of the term. Sadly, J goes so far to say that there was, in reality, a statutory conveyance of the original lease with the benefit and burden intact. So we will see what are the complexities that arise when a tenant who has lost their title to adverse possession, if he surrenders their lease to the landlord. The question is whether this act of surrender terminates the lease and enable the landlord to take action against the adverse possession. So in the case of Fairweather versus Sun Marylebone Properties Co. Limited in 1963, this is the case of unregistered land. It's provide a clear answer. In this case, the House of Lord held that when a tenant against the whom the adverse possession had been successfully completed and he surrendered the lease to the landlord, the lease is effectively terminated. This termination occurs even though the tenant still maintain an estate via the landlord. With the lease terminated, the adverse possessor no longer has a right to remain on the land in the face of action by the landlord. So the landlord right to possession is now active. From the strict logical and theoretical standpoint, this ruling is difficult to fault. However, from a common sense perspective, it may seem unfair that the ejected tenant has power to surrender the lease that has essentially become an empty shell due to the adverse possession. This inequity becomes even more apparent if the landlord, after evicting the adverse possessor, re-grants a new lease to the ejected tenant. Despite the powerful criticisms of these rules from both judicial and academic circles, it is unlikely to be overruled. So it is important to note that this rule applies specifically in the context of the unregistered title, which is becoming less significant as registered title systems gain prominence. The substantial nature of adverse possessions. In the case of Turner versus Chief Land Register in 2013, the nature of an adverse possession right was examined in the context of applying for a caution against the first registration of the title. So the court held that the adverse possessor must have had a legal estate in the land, specifically a fee simple absolute. In order to be eligible to register a caution, this decision emphasized that even during the process of acquiring the title through adverse possession, the adverse possessor possesses a valuable property right. So, an adverse possessor who is in the process of completing the limitation period can transfer the right they have occurred to another person, either through a will or an inter vivos transfer. For example, if an adverse possessor has paused the land for 2 years, they can transfer those 2 years worth of possession to another person. This period can be added to any period successfully completed by the recipient of the adverse possession right, allowing them to accumulate of total 12 years. So the should be 12 years worth of adverse possession, which is often the threshold for acquiring the full membership through the adverse possession. It is also worth noting that if one adverse possession disposed by another adverse possession, the current adverse possession can claim the combined period of adverse possession of the both individuals in order to defeat the legal owner. So he can combine both. For instance, if person X disposes the legal owner 5 years and the subsequent dispose to the person Y for 7 years, so the Y can claim a total of 12 years worth of adverse possession. So 5 plus 7, 12 years he can claim to establish the claim of ownership and defeat the paper owner. So, in summary, even before completing the period of limitation, an adverse possessor possesses certain rights in unregistered land. So, that's the essence. So, these rights, although not absolute, can be transferred and accumulated, although the adverse possession to occur full membership through the adverse possession if required period is successfully completed. We will see how the adverse possession works when under the Land Registration Act of 1925. If a land is registered but governed by LRA 1925, the same limitation period applies as in the case of the unregistered land. How whatever we have seen in unregistered land, same thing applies here. This means that adverse possession of 12 years is usually required to claim the ownership through the adverse possession. Before the LRA 2002 came into force on October 13, 2003, if someone completed 12 years of adverse possession, they were entitled to the register as a proprietor of the land. In such cases, the land was held on trust by the registered proprietor for the successful adverse possessors. However, in LRA 2002 abolished this trust and replaced it with the entitlement to the registered as a owner. So this entitlement to be registered can be enforced against the purchaser of the land from the current registered proprietor if the adverse purchaser is in discoverable actual occupation of the land. So it will allow them to claim an interest that overrides the purchase rates. If the transferee is not a purchaser but a different type of transferee, the right to be registered is binding under the basic priority rules in section 28 of the LRA 2002. Importantly, this is a very important point. If the adverse possession had not fully completed 2 layers of adverse possession before the LRA 2002 came into force, so the situation is governed by the provisions of 2002 Act only. So even if the period of adverse possession was nearing completion on the day the Act entered into force, so the adverse possession does not acquire the right to be registered when 12 years has passed. The period of adverse possession, if less than 12 years on 13th October 2003, may count towards the relevant period under LRA 2002. But it does not grant any right to the title of the land. So, the traditional rules of adverse possession apply to the registered land only if the 12-year period of limitations is fully completed before 13th October 2003. Under the Land Registration Act 2002 to LRA 2, 2002, the law concerning the adverse possession has undergone significant changes, particularly in relation to the registered land. There are a lot of changes being made. While most of the case laws in these areas previously dealt with the unregistered land or claims under the LRA under 1925, there are now cases being decided under LRA 2002. So LRA 2002 introduced a new scheme for regulating the effects of adverse possession on the registered land. It is important to know that the provisions of LRA 2002 are fully in force and will govern the majority of adverse possession claims in the future. So the underlying premise of LRA 2002 is that a state guaranteed title, which can be readily proven from the title register. should not be lost solely due to the possession of the stranger, regardless of how long the possession has been lost. This principle is in line with the concept of title by registration, which emphasizes the importance of registered title over the mere possession. In practical terms, LRA 2002 has established a stricter regime for adverse possession of registered title. In order to claim adverse possession, the possessor has to satisfy certain criteria and follow specific procedures as set in the legislation. These requirements aim is to protect the integrity of the registered title and ensure that adverse possessors cannot easily acquire ownership right through the long-term occupation alone. So just by because he is there for 12 years, he can whether he can go and secure your property. That's to in order to stop that. It put the LRA 2002 has significantly modified the scheme for adverse possession on the registered land. Also, they prioritize the registered title and implementing the stricter requirements for the adverse possessions. So these changes aims to ensure the stability and reliability of the land registration system in the face of adverse possession claims. So it is worth noting that LRA 2002 introduced a system of overriding interest. So which means that some interest, such as those a person in the actual occupation, may still take the priority of the registered owner title, even if the occupation is not apparent from the title register. So this provision seeks to strike a balance between the protection of registered owners and recognition of legitimate interest in the land. So the adverse portion under the Land Registration Act 2002, we will see the basic principles outlined in the passage. Is that under the LRA 2002, there is no time limitation against the registered title. This means that registered proprietor cannot lose their title simply because someone else has adversely possessed the land for a specific period of time, as stated in Section 96 of the LRA 2002. However, LRA 2002 acknowledged that the claim of adverse possession still occur that removing the time limitation alone will not prevent disputes for the land title. So to address this, 2002 Act established application procedures where an adverse possessor can apply to the register to be registered as a proprietor of the title. This application triggers the statutory scheme outlined in the Schedule 6 of the Act. So as a result, the burden of making a claim to the registered title shift to the adverse possessor. So the registered proprietor is not required to take any action to maintain the title unless the adverse possessor applies for registration. So the registered proprietor can rely on this new system to alert them to any adverse claims, allowing them to respond and protect their interest in the land. So in summary, if you see LRA 2002 eliminates the time limitation for the registration title, but provides a procedures for adverse possessor to apply for registration, shifting the burden of proof to them. So this allows the registered proprietor to rely on the system to notify them of the adverse claims and take actions accordingly. So the statutory scheme under the LRA 2002, a person who has been in adverse possession of the property for last 10 years can apply to the register to be registered as a proprietor. So, however, it is important to note that 10 years of adoption have actually occurred and are ongoing at the time of applications. So, if the registrar believes that application presents a valid case of registration, a notice will be sent to the current registered proprietor and other relevant parties, such as those with a mortgage or lease or other registered title. So, upon receiving this notice, the registered proprietor and other recipients have three options to respond. The first option is for the registered proprietor to consent to the application, so resulting in the adverse purchase being registered as a proprietor. So this option is unlikely to be common, but has occurred in such cases in Ballyman's Limited versus Satori in 2011. The second option is for the registered proprietor to object to the application. So first he has to consent. The second is object. If an objection is raised, the application cannot be finalized until the objection is resolved. If a negotiation settlement cannot be reached, the matter may be referred to the registration division of the property chambers of the first tier tribunal for a decision. So the objection is likely to be based on the claim that factual basis of adverse possession is false. The third option available to the registered proprietor is to serve a counter notice. So this option allows the registered proprietor to challenge the application regardless of the validity of the factual basis of the claims of the adverse possession. So the counter notice procedure enables the registered proprietor to defeat the application. This response is likely to be chosen when the registered proprietor can clearly disprove the claim of adverse possessions or cannot invoke a two-year rule. It is worth noting that a two-year rule is not discussed in the specific excerpt, but it is likely referred to the provisions that allows a registered proprietor to defeat an application for adverse possession if they can prove that they have been in possession for the property for at least 2 years after the adverse possession's 10-year period ended. So, in summary, the second response of objection by the registered proprietor is likely to occur only if the registered proprietor can clearly disprove the claim of adverse provisions or cannot rely on the 2 year rule as a defense. So, by serving a counter notice, the register proprietor triggers a procedure governed by the paragraph 5 of Schedule 6 of 2002 Act. So, this procedure states that regardless of whether the adverse person has made the factual requirement of the adverse person, they cannot be entered as a new register proprietor unless one of the three exceptional grounds is being established. If none of these exceptional grounds is established, the register proprietor is given an additional 2 years from the application by the adverse purchaser to recover the portion of the land. So during this 2 year grace period, the register proprietor has a right to recover portion simply by the virtue of being the owner, regardless of how long the adverse purchaser has been portion. So they will disregard how many years he was living. So if the registered proprietor fails to recover the portion within these 2 years, then the adverse purchase may reapply at the end of the 2 year period and be entered as a new proprietor of the land. So if he hasn't recovered successfully, then he can adverse purchaser can apply after the end of 2 years period. So this new scheme has significant impact on the frequency and success of adverse portion claims. Further, this process applies regardless of the duration of adverse application, so there is no statutory period of limitations. Therefore, if the adverse position does not apply for a registrar or is evicted, the registrar is protected. So this explains why the landowners with extensive and diverse land holdings, such as local authorities, are opting for the first registration of the title as it provides significant protection against the adverse possession claim. Now we will see the exceptions. The significance of exceptions listed in Schedule 6 of the LRA 2002 in relation to the disputes involving the registered proprietor and adverse possessors. So, the LRA 2002 provide a robust protection to the registered proprietor, allowing them to evict the adverse possession within 2 years of adverse possession application for the registration, even if the factual basis of the adverse possession is already exist. So the exception listed in Schedule 6, paragraph 5 of LRA 2002 are unconscionable disposition, other entitlements, and boundary disputes. What is the unconscionable disposition? The exception applies when it would be unconscionable for the current proprietor to dispose the adverse possession due to an estoppel. In such cases, if the circumstances are such that the adverse possession are to be registered, they may be entitled to the registration. So the other entitlements are the second point is the other entitlement. This exception applies when the adverse possession is entitled to the registered as a proprietor for some other reason not explicitly stated in the Act. The boundary dispute is this exception applies when there is a boundary dispute concerning the adjoining land. If for at least 10 years of adverse possession, the applicant reasonably believe that disputed land to be theirs. So the disputed land has been registered for more than 1 year to the application. The adverse possessors may be entitled to the registration. So, in summary, the exception outlined in the Schedule 6 of LA play a crucial role in determining whether an adverse possession can overcome the robust protection provided by the registered proprietor and have a realistic chance of being registered as a proprietor. Exception 1, Estable unconscionability and ought to be registered. So the exception incorporates the principle of the proprietary estoppel into the law of adverse possession. The estoppel is used as a remedy for unconscionable conduct. So it requires the applicant to demonstrate not only the factual portion and intention to possess the property for at least 10 years, but also detrimental reliance on an assurance by the registered proprietor. There are two examples. One first example involves a squatter building on the registered property land under the mistaken belief that they own it, and the proprietor knowingly allows this mistake. The second example involves neighboring parties entering into the informal sales agreement where one party agrees to sell the land to the other for valuable consideration. The buyer takes the portion of the land and treat it as their own but fails to perfect their title through registration. So there is no binding contract. It is stated that estoppel can be based on both express and implied assurance by the acquirents. It can support a failed contract. However, it remains uncertain whether the ground for gaining title by adverse possession through estoppel will be interpreted broadly or narrowly, as a court are generally hesitant to categorize case rigidly. So the passage discusses the incorporation of estoppel principle into adverse possession, and it raises questions about the relationship between the estoppel and adverse possessions as well as the scope of these exceptions. The court discretions in refusing the registration despite the existence of an estoppel claim. Additionally, the Schedule 6, paragraph 5.2 does not explicitly state that an adverse possessor will be registered as a proprietor if they can support their possession claim with an estoppel. The applicant must also establish that they are to be registered. This raises the possibility that the court had a discretion to refuse registration to an applicant, even if they have met the requirement of 10 years adverse possession and the establishment estoppel. So, the basis for such a refusal and whether the adverse possessor can pursue an independent claim is estoppel for the same or different remedy in such cases would need clarification through judicial interpretations. Now we'll see what is the exception to the squatter is for the some other reason entitled to be registered as a proprietor. This provision is considered somewhat vague and open-ended, which may make it attractive to adverse possessors who are concerned that the registered owner of the property may take advantage of 2 years grace period. One possible interpretation is that without adverse possession, a person who is entitled to the property would have to apply for the rectification of register against the registered owner under the Schedule 4 of the 2000 Act. However, such an application for rectification might be refused. Therefore, it may be the intention that if the adverse possession support an entitlement, the claimant can bypass the limitations on rectifying the register by using the route of adverse possession. So, the exact scope and application of the action, however, not immediately apparent. The tribunal judge in Judge McAllister in the case of Crosdale versus Hooder in 2011 noted that the example provided by the commission were instances where the claimant could obtain a remedy without relying on adverse possession. So, as a result, she concluded that the exception should be interpreted narrowly and should not be used to support adverse possessors based on the broad interpretation of the entitlement. So we are on the last slide. Now we are going to see the boundary exceptions and the effect of registration for the adverse purchase under the LRA 2002. By this, we are concluding this chapter, and I have covered most of them. To establish a claim of adverse possession under the boundary exceptions, there are four conditions must be met. The three of these conditions are factual, need to be proven, urgency of the application land to the land in question. So, undermined, undetermined exact boundary, and registration of the land for more than 1 year. The fourth condition relates to the applicant's belief that land belonged to them for at least 10 years during the period of adverse possessions. So the interpretation of this fourth condition has been subject of uncertainty and debate. It is unclear whether the reasonable belief should persist for 10 years up to the moment of the applications, or if a reasonable belief for the any 10-year period before the application is sufficient. The awareness of the registered owner objection to the adverse possession claim and its impact on the reasonableness of the belief is also uncertain. Prior to the entry into force of the LRA 2002, a landowner had to be attentive of his estate, and failure to use his land meant that others could acquire the title to it, so perhaps use it more beneficially. It is seen in Lambeth LBC versus Ellis 2000 case and Kubrick versus Hackney LB in 2003 case. So after the entry into the force of LRA 2002, a landowner with a registered title can sit back and wait for the registrar to inform him that his land is subject to another claim. Then he can usually evict at any time within next 2 years. So then he can sink back into the slumber. Now we are entering into the last topic of this chapter. Under the LRA 2002, if an adverse purchase successfully registered as a proprietor of the land, they will take the land subject to any interest that affect the estate, with the exception of any registered charges. So, however, if the registration is as a result of one of these three exceptions, the adverse purchase will also take the land subject to any registered charge. So the reason for the difference lies in the fact that a registered chargee, typically a bank or a lender, holding a mortgage over the land, so would have been served with a notice regarding the adverse possession claim. So in such a case, the chargee would have had the opportunity to request the application be dealt with under the 2 year rule, which would have allowed them to preserve their security. So if the chargee failed to take action to evict the adverse possession, despite being served the notice, it can hardly object to the loss of its charge. So, however, if the adverse posture registration is a result of one of the exceptions, what we have seen above, it means that mortgagee was unable to take advantage of this 2 year rule and he cannot challenge the registrations. So, in this situation, it is considered appropriate for the adverse possessors to take the subject title to all the encumbrances, including the mortgage. So, in summary, the effect of registration as a result of successful adverse possession is that the adverse possessor takes the land subject to all the interests affecting the estate except any registered charges. So if the registration falls under one of the exceptions, then the adverse possessor also take the land subject to any registered charge. Thank you, my friends.